discretionary bars. The court may, in its discretion, refuse to make a decree of marriage if since the marriage, this is section 28, the court may in its discretion refuse to make a decree of marriage if since the decree the petitioner has committed adultery that has not been condoned by the respondent, or having been so condoned has been revived.
That's the further part.
B. The petitioner has willfully deserted the respondent before the happening of the matters relied upon by the petitioner, or where those matters involve other matters occurring during or extending over a period before the expiration of that period. C. The habits of the petitioner have, or the conduct of the petitioner has conduced or contributed to the existence of the matters relied upon by the petitioner. So the court in its discretion, the court may in its discretion refuse to make a decree of marriage. I think this is wrong. It's supposed to be a decree for the dissolution. Decree of dissolution of marriage. That's what it's supposed to be here. If since the marriage the petitioner has committed adultery that has not been condoned by the respondent, or having been so condoned has been revived. B. The petitioner has willfully deserted the respondent before the happening of the matters relied upon by the petitioner, or where those matters involve other matters occurring during or extending over a period before the expiration of that period. C. The habits of the petitioner have, or the conduct of the petitioner has conduced or contributed to the existence of the matters relied upon by the petitioner. Tracy.
Read it again,
No.
Basically, it's just saying that the court has discretion to refuse to grant an order for dissolution of marriage if the first one, if the petitioner had cheated on his or her wife, even if the respondent had decided to overlook it, the court can still decide to grant the order for the dissolution of marriage.
No, they will not grant. The court will not grant it. If you, as the petitioner, you had already been involved in cheating, now you are
that wants to come and divorce
to complain about the respondent. Meanwhile, the conduct of the respondent that you are relying on is a product of your own earlier behavior, such as cheating.
No. You said the court will.
That's what I was stressed.
Start it again.
Such as cheating, then desertion.
Then the second one, if the petitioner had deserted the respondent before the issues that the petitioner is relying on arose, the court will also refuse to grant the order for the dissolution. Then the last one, if the habits of the petitioner or the conduct of the petitioner contributed to the conduct of the respondent that the petitioner is relying on, the court will also refuse to grant.
But is this thing proper?
Yes,
It's proper.
I think it is.
Why?
Because
Me now that is the petitioner, I have done things that are detrimental to the marriage. The respondent did not petition. Now the respondent has now done his or her own. I still now petitioned. Right or left, the factors that should initiate the ground of dissolution have been performed by both me previously and by the respondent subsequently. So why now force us to continue?
I think where the challenge will be is that if the respondent now is fighting that petition, you understand? If the respondent is fighting the dissolution, that the respondent is minded for it to continue.
For the marriage to continue.
Because the court now is looking at it from this angle that you have done your own. You understand? And then you got away with it. I did not petition you. Now, at least you can bear with me small first. Let me do small. Bear with me small. I think that's the rationale.
because under the marriage marriage under the Matrimonial Causes Act is more like equality. because he sees it as a contract. And as a contract, both parties has the obligation to play. Not like the religious or the traditional way where say the man is the head of the family, the woman is subordinate. That's why under the Matrimonial Causes Act, anybody can apply for alimony depending on who has the upper hand. If my wife is richer than me, at that point of divorce, I can tell the court that, my lord, I need to survive till I get another job. This woman has more money than me. She is the breadwinner, and the court will grant it.
So what we have been able to see here is that
your own conduct should not come and affect my own.
Yeah, so this divorce thing is actually a very dicey, is a very complicated proceeding, and it's something that if the defendant lawyer, respondent's lawyer, wants to make unnecessary case and trouble and stress, it can stress you with a lot of clause. With all these clauses.
Because if you cheated and you now made me cheat,
then
you now come and fire.
Cheating to fire.
Fire. No, now.
That means no man. That is why men, I think, I notice generally men are skeptical with filing divorce proceedings.
Okay.
Because it will always.
Because if a man files a divorce petition, it's most likely the woman who can establish his. So she say, I have condoned you. If I don't do, yeah, condone me back. I think come on, relax. I think the implication is that he who comes to equity
must come with me.
So if your hands are soil, and then you are coming to establish the soil on your partner's hands, the court will not oblige you because you are not your hand is not clean. You are guilty as charged. So except your partner is also willing to, by counter claim, dissolve the marriage.
That's why it's a dicey situation.
It's a very dicey situation. I think now I'm beginning to see it as is it do or die, or better for us? Not better for us, do or die.
Because the court, especially when there are children,
this one makes it do or die.
This one is do or die.
It's do or die. It's not better for us. You must agree. You must pay.
you must marry.
Because when the court says don't they, and people say, and okay, there's even restriction of conjugal rights. Because they go and continue.
You must obey the order of court.
The court can compel you to
perform your conjugal duties
when you want to
work.
But despite all these factors, it must be central and center.
Yes.
That's
because we are lawyers. That's why we are explaining this law. So that when we are going to court, we know how to.
The thing is that most of them, the parties are interested in the divorce. So what we understand, the parties are interested in divorce.
In most of the
circumstances, the parties are.
I think in a few of the circumstances, what I've noticed is that
while the party said he doesn't want to divorce, you cannot do.
In a few of the circumstances, what I've even realized, while the woman petitions, the man is always trying to clear the record of adultery, cheating, as the case may be. So to clear, because whatever goes as a judgment is a record of court, is a public document that is certified, can be useful for anything. So if tomorrow somebody wants to establish that you are an adulterer, they just need to bring the court records.
Or you want to do defamation, somebody is called you an adulteress. You want to do defamation, the person will bring that CTC as truth.
Yes, so most times the parties introduce a level of defense on those points. While defending those points, if they don't press for the dissolution, it might now stall the dissolution and compel the marriage to proceed.